Thank you very much, Sam, and I certainly want to welcome everyone to today's session. I want to thank you for taking some time out of your day so that we can delve a little deeper into the Visa chargeback process than I've done with some of the previous sessions that we've offered through BOL Learning Connect. In the materials, I have continued to include the description of some of the various chargeback codes that are available to us for the various disputes that may arise over the course of our Reg E and non-Reg E processing. But we're going to be focusing today much more on those merchant representments and how we as bankers can respond to those representments, whether we're going to be denying a Reg E claim, whether we're going to be continuing an investigation. And we're going to focus on what are the options that we can do to try to minimize the losses for both ourselves as well as for our customers. And the reason that this presentation really came about is as I've reviewed Reg E claims at some of the financial institutions that I've been at, I often find that once they receive a representment of a previously disputed transaction, they really consider only two options. They either decide, well, we're just going to have to write this off as a loss because we lost our chargeback, or we determine that we're going to charge the transaction back to the customer and deny their claim. And occasionally, especially for the ones where the bank actually writes off the charge as a loss, I'll have a conversation with the operations staff and just ask them why they haven't filed for pre-arbitration in some of the cases where they could have possibly recovered funds. And the response that I often receive was that, well, the arbitration process is way too expensive, so it's not worth it for us to pursue the transaction any further. We're just going to write off the charge and be done. And on the one hand, I agree and I understand where they're coming from because, as we will discuss, the cost of arbitration can stretch into hundreds of dollars. And so the thought process of cutting our losses rather than rolling the dice hoping to recover funds for the bank may not seem too terribly appealing. And so the key for arbitration and the key for successfully navigating Visa's rules regarding arbitration is to know when we can actually win one of these claims by going into the pre-arbitration process and knowing when we can put that liability back on the cardholder. Because understand that in the arbitration process, the arbitration fees generally get assigned to the losing party, whether that's the merchant or whether that's the financial institution. And so it's not just us rolling the dice. It could be the merchant rolling the dice if they decide, hey, we're going to try to fight the bank on this one. And so we may find there are times where merchants are willing to back off of a transaction because they realize, hey, they could be on the financial hook for it, plus the arbitration fees. And so we can win some of these claims going deeper into the chargeback process. So for our discussion today, we're going to look at the various responses that we can expect to receive from merchants when they represent a transaction. And then we have the decision of what to do with this information. Are we going to deny the Reg E claim? Are we going to continue the investigation? Are we going to write off the charge and close the case? And so we're going to look at these appropriate times for filing pre-arbitration and then consider the consequences, both positive and negative, for taking the case all the way to Visa for arbitration. Compliance, that's a completely separate animal. And so we're going to talk about some of the common rules violations that a merchant may commit that limits our recovery options through the chargeback process. But when the merchant has one of these rule violations, this may open up the compliance process for us to pursue, again, in order to recover the funds on some of these disputed transactions that we would otherwise be losing. So as we begin our conversation about second presentments, which is also known as representment, depending on who your card processor is, again, there's a common misconception with respect to this stage of the chargeback process that I want to make sure we clarify right at the start of today's session. Many institutions, I find, assume that once they receive a second presentment from the merchant, that means Visa has already placed its stamp of approval on the documentation that the merchant has provided to us. And this is actually not the case. The purpose of the chargeback process is for the issuer and the merchant to work things out between themselves using Visa's infrastructure. But at this stage of the process, we're not involving Visa directly. They're simply providing the conduit of communication through the chargeback process for us to say to the merchant, hey, we think you should be liable for that. The merchant should then produce documentation and say, no, we think the bank should be liable for that. But Visa's not really monitoring the documentation that goes back and forth at this stage of the process, which means as a merchant, I could create a representment, send you a stick figure drawn by my 9-year-old son, and call that supporting documentation for refuting a chargeback, and the process is going to get the merchant's money back from the bank in that case. So the question then becomes, what's the bank going to do about it when it receives bogus documentation or improper documentation? Essentially, a representment, all it does is kick the ball back into our court, and then we get to decide, do we have enough information to deny a Reg E claim? Do we have enough information to decide, yes, the customer did not authorize the transaction and honor the Reg E claim? Or do we need to go back to the merchant and get better information or more detailed information? Again, ultimately, these three choices are up to your operations staff to decide what direction you want to go. So the first set of representments that we're going to look at, this particular slide, these could apply to any of the chargeback reasons that we're going to be covering. These situations all apply to errors that the financial institution may have made during the initial chargeback process. And while it's true that most smaller institutions do rely on a processing company to file chargebacks on their behalf, we want to make sure that our vendor is assisting us properly in avoiding many of these common errors. If we do receive a representment for these circumstances, understand that our pre-arbitration rights are going to be very limited in trying to refute the merchant's claim, because once a mistake has been made in the chargeback process, Visa will assign liability automatically to the party that made the mistake, whether it's the issuer or whether it's the merchant. And so even if the merchant does violate Visa rules in how they process a transaction, if we don't file our chargeback correctly, then we're going to end up being the ones holding the bag because we didn't follow Visa's dispute rules properly. And so the first error that we're going to look at relates to dispute documentation. One of the most common errors is simply forgetting to include the cardholder's dispute letter with the dispute documentation. And the representment right doesn't stop there either. The merchant may represent if the cardholder letter doesn't contain all of the required information. So, for example, if I'm filing a dispute due to a fraudulent transaction, the cardholder letter is required to then state, I did not authorize this charge. If nowhere in the documentation that we provide to the merchant does the cardholder actually state that the charge was unauthorized, then the merchant can simply say, well, we don't know what the dispute reason is, even though we filed a fraud-related chargeback. We don't have any documentation to substantiate that it's fraud from the cardholder. The merchant can then go back with an invalid documentation representment and push the dispute back onto our desk. And because we made the mistake, the merchant doesn't even have to provide any proof to show that the cardholder did the transaction. And so this can paint us into a bad corner because now we've filed a chargeback, we've not gotten any information back from the merchant to tell us about the charge, and we've still got a Reg E claim that we're dealing with, and no information to prove the customer did or didn't do the transaction. So by making a simple mistake of not filling out the cardholder dispute letter properly, we end up with a situation where we're going to take a loss simply because we don't have the information that we need to make a determination about the transaction. It's also important to make sure that the documentation that we provide is legible. If the merchant goes back to Visa and says, hey, I can't read this, and Visa agrees, there again, the liability is going to pass back to us. One of the requirements with respect to dispute documentation is that it has to be in English. And so if we